what does it mean for a jury to be hung? Let's talk about that. I'm Joel Chorny. I'm a criminal defense attorney here in Tucson, Arizona, and I just had a trial and we ended up with a hung jury. As I've told people about that, I have gotten pretty much a consistent reaction, which is, what does that mean? What's going to happen next? So that's what I want to talk about today in this video. Before I get started, let me go through a disclaimer. I am licensed to practice law in Arizona, and so I can only take on clients with matters in Arizona. If you're looking for legal representation or assistance, consult with an attorney who is licensed in the jurisdiction of your matter. These videos are not meant to be legal advice. They're meant to be informative. I'm not creating an attorney-client relationship with anyone who watches these videos. Now that we have that out of the way, let's talk about it. So here in the United States, the requirement of a unanimous verdict varies from state to state. There are states that allow for partial verdicts, verdicts that are by a majority rule. Usually it's some percentage of the jury needs to agree. But here in Arizona and in most places, a verdict needs to be unanimous, meaning that every juror agrees on the verdict, be it guilty or not guilty. And when the jury cannot agree, they end up being hung, and that results in what's called a mistrial. And unfortunately, the requirement of double jeopardy or the preclusion of double jeopardy doesn't apply to such mistrials. So the state has the option of trying again. In my case, this trial that just ended, we ended up with a split that was 8-4 for not guilty, meaning that a greater majority of the jury was under the impression that the state had failed to meet its burden of proof beyond a reasonable doubt and was ready to acquit my client. Unfortunately, there were 4 holdouts who wanted to convict my client and they couldn't agree. And so now we're waiting to see if the state is going to elect to try the case again. Here in Arizona, there is a speedy trial rule for retrials under those circumstances, which is the trial has to happen within 60 days. We're not going to demand that. My client is not in custody. We're not in a hurry to try this case again. So we'll see when we actually set this case for trial, if we're going to end up setting it for trial. But the reaction I've gotten from people when I've mentioned how this works is, well, wait a minute, why does the state get to try the case again? If there were so many people in the jury room who felt like the state hadn't met its burden of proof, shouldn't that be the end of it? And I tend to agree that it should be that way. The way I see it is the state has to prove its case beyond a reasonable doubt. And if there's a person in the jury room who doesn't think that they did that, that means that they didn't prove their case beyond a reasonable doubt, and they shouldn't be allowed to try the case again. Unfortunately, there isn't a jurisdiction here in the United States that does it that way. We could do it that way. There are certain phases of proceedings where that is kind of the way it works. For example, in death penalty cases, I know that here in Arizona, once they get done with the guilt phase, death penalty cases are strange because there's the guilt phase of whether or not the person did it, but then there's the penalty phase where the jury decides whether or not to impose the death penalty or give the person a life sentence. Death penalty cases are the only type of criminal case I'm aware of where the jury actually hands down the sentence. Ordinarily, the matter of sentencing is strictly for the judge, for the court, but death penalty cases are different. But anyway, coming back to that, in death penalty cases, at least here in Arizona, and I know there are other states like this, if the jury doesn't agree unanimously for the death penalty, that's it, it's life. The state doesn't have the opportunity to try again for the death penalty. We could certainly have a rule that says that if the state doesn't convince the jury unanimously to convict in the first instance, that's it. The case is over. That would be effectively an acquittal. I think that would be much more efficient. I think that it would force the state to really try its best in that one trial to make its case. And then if they didn't make it, they didn't make it. Now, of course, I will concede that I am biased. I'm a criminal defense attorney and I see the world through the lens of a criminal defense attorney. But the way I see it, if this is about protecting people's rights and holding the states to its burden and making sure that they bring their A game, that would be an effective way to do that. The thing I dislike the most about the way we do things is that the conviction rate, which is already very high for trials, becomes much higher for retrials. In my trial that I just did, I actually reserved my opening statement, meaning that I didn't give my opening right after the state gave theirs. I reserved my opening until after the state had rested. And once they had rested their case and they were done presenting it, then I got to give my opening. And I did that on purpose. I didn't want to tell the state what I was planning on doing. There were a few nuanced things in this case in particular that I felt that the state would not anticipate if I didn't give an opening. And so I reserved my opening. Well, now they've seen my case. They know what I'm going to do. So if we do end up doing a retrial, I don't have that advantage anymore. The trial is going to look very different that second time around. And all else being equal, just as a matter of odds, odds, chances are much greater that my client will be convicted in a retrial, which is just, it's the way it's set up. But it's unfortunate. I certainly appreciate that verdicts need to be unanimous. At least a guilty verdict should be unanimous, but I don't necessarily agree with the idea that a not guilty verdict should be unanimous. But it is the way it is. It's just a matter of how we have set up the system. I mean, there are jurisdictions across the globe that don't use juries at all, where they let judges decide the entirety of the case. I frankly am partial to the jury system. I think that the jury system is a good check on governmental overreach, but juries are unsophisticated and they're surprisingly dense. They don't understand the law the way the attorneys do. And some might say, well, the attorney's job is to help them understand the law. And I agree with that, but it's quite difficult to impart a concept like proof beyond a reasonable doubt standard to a jury who's never really grappled with that topic. And frankly, attorneys mess it up all the time. Here in Arizona, we have an instruction on how proof beyond a reasonable doubt works called the Portillo instruction, because it comes from a case called State v. Portillo. And what it says is that very few things in this world can be proven beyond all doubt, and we don't require the state to prove their case beyond all doubt, just beyond a reasonable doubt, and that if the jury is left firmly convinced of the defendant's guilt, then they must find the defendant guilty. However, if they feel or find that there is a fair possibility that the defendant is not guilty, then they must return a verdict of not guilty. And what I have seen happen in pretty much every trial I've done in front of a jury is that the state's going to really lean on the whole, we don't expect the state to prove anything beyond all doubt. And as long as you're firmly convinced, they'll talk about that part of the instruction. And then the defense attorney gets up and talks about that latter part of the instruction, talking about how if there's a fair possibility that the defendant did not commit the crime, then you must acquit him. And it's silly because it's all part of the same instruction. And the instruction itself is confusing. It's worded in a way that is it's filled with double negatives, and it's just not a clear instruction. And I think that's by design. I think we don't want to give juries that kind of clarity. I don't really know why, but we don't. And juries are often left to sort of guess how they think the standard of proof beyond a reasonable doubt works. And it's uncomfortable. So that's how hung juries work, on how the requirement of unanimous verdicts works. And it's a strange quirk. It's a strange quirk of our system. It doesn't have to be that way, but it is that way. And it's been that way for quite some time, but it could change. It's not going to change anytime soon, though. Part of my frustration is tied to the fact that here in Arizona, they took away our peremptory challenges, which is strikes without cause. In most states, I think pretty much every state for now, except for Arizona, the process of selecting a jury is such that, yes, you strike jurors for cause, meaning you say why it is that the juror is not qualified to serve on the jury. And if you persuade the judge that that is correct, then the judge will strike them and they go. But then there are peremptory challenges where you can just strike jurors for any reason you want or no reason at all. And that's a way of getting rid of the jurors that give you the feeling that they're not going to give your client a fair shake. And here in Arizona, they did away with that. They claim it's because they were tired of dealing with the litigation about whether or not people were excused from juries for improper purposes, which would basically be race or gender, which is not allowed under the Constitution. But people were apparently striking jurors for those reasons and then claiming or I should say race neutral or gender neutral reasons, which is the way the process is meant to work. But the state Supreme Court here in Arizona decided they didn't want to play that game anymore, so they just did away with peremptories. It's a very stark example of throwing the baby out with the bathwater. And so now we end up with this jury selection process where you have to try your darndest to really get to know those jurors before they are sworn in on the jury, and to try to develop challenges for cause, which is quite difficult. In this last trial, I had people on the jury that I would have never dreamed of having on this kind of jury for this kind of case, but there was no way to get them struck in for cause because they said they'd be able to be fair and impartial. And when I explored the things that I thought would make them unable to do that, they answered the questions in the right way. Not necessarily in a truthful way. There's really no way to tell if the jurors are telling you the truth, but if they say the right words, judge isn't going to strike them because they said all the right things. So it's a strange thing to get a hung jury. This was my first hung jury. Actually, I've always gotten a verdict when I've tried a case, except for this time. And among criminal defense attorneys, it's understood that a hung jury is the second best result, right? Because it means your client is still innocent. And in this instance, my client got to go home, got to sleep in his own bed, and it's going to be a few months before we try the case again, if at all. So it's a good outcome, but it didn't feel like that because, frankly, I was tired. This was a 2-week trial, and to try it again, I'm already kind of sick of it. Like, it's kind of like eating the same thing for 2 weeks, and then someone says, "Hey, here's more," and you're like, "I'm done with it. I've had enough." So part of the challenge is going to be to get excited about this case again, which I'll be able to do. And once we have a new trial date, if that's what's going to happen, I'll be prepared, and I will certainly try it differently. I won't be reserving my opening this time, and we'll come up with new things to say to the jury to hopefully persuade them to acquit my client. Anyway, that's how it works. If this surprised you, if you know that things work differently in your jurisdiction, if you have questions about this, drop them in the comments. I'd love to hear from you, and share this video with anyone that you think would find it interesting. I was surprised at how few people actually understand what happens when a jury cannot reach a unanimous verdict. And so now you know. So thanks for watching. Remember that your rights matter. They're important. Protect them. Protect yourself. Be safe. And I'll see you guys on the next video.